Welcome to the Probate Professor.
Welcome to the Probate Professor with attorney Taylor Waite of Clear Counsel Law Group. Navigating the Nevada probate system can be overwhelming, but you don't have to do it alone. Taylor helps Southern Nevada families clear the legal hurdles and protect their legacies with confidence. I'm Leanne Lyon, and today we're talking about what assets go through probate in Nevada and what assets don't. Hello, Taylor.
Hi, Leanne. Thanks for having me today.
It's great to see you. Taylor, how does Nevada law determine whether something becomes part of the probate estate and what doesn't?
It's a great question. And as you can imagine, that's really the first question we get into. It's not exactly straightforward, but sometimes the way I like to have clients work through it is that imagine after mom or dad pass away, you're going through paper, you have a stack of paper in front of you, and each sheet of paper represents a different asset. You're going to look at that sheet of paper, and the first thing you're going to look at is title ownership. If there is a joint owner on that asset, it's possibly not a probate asset, so you'll put that in a different stack. If it's owned by a trust, that goes in a different stack. But at the end, you're going to have those assets that are titled only in the name of the deceased, just their name. And then you're going to take one more step and look to see if there are beneficiary designations associated with any of those assets, and put those aside as well. Then what you're left with is a stack of assets that identify only the individual that's passed away. Those are the assets that will likely have to go through the probate process in some form, depending on the nature and value of those assets. And as you go through that process, it's important to note that it's a date of death snapshot. Sometimes we're dealing with assets where the individual that passed away a decade ago. So the deaths that have occurred in the interim can sometimes affect what originally was a non-probate asset may still be a probate asset now because of the order of deaths. But just a broad sweep, you're going to look first at title ownership and then look at if there are beneficiary designations. If what you're left with is an asset that is titled only in the decedent's name with no other designation, that's an asset that likely has to go through the process in Nevada.
So, if somebody passes away owning a home, vehicles, or bank accounts in their individual name, how are those assets handled during probate in Nevada?
I like to explain Nevada probate as being subject to the nature and value of the assets. That's going to be the next step in the process. For example, if any of those assets, as you indicated, include a home, then the value is not really relevant as far as whether or not you have to go to probate. The value will affect which process you have to follow. But if there is a piece of real estate, you have to go through the probate process. And then it really is a question of nature and value of the assets. Nevada right now, based on some recent statutory changes, the most important threshold, it's $150,000. So if the net assets are greater than $150,000, you're going to have to go through some form of a probate in the state of Nevada. But there are other processes available. Again, I apologize for repeating based on nature and value. If assets are under $150,000, even if they're owned by the individual, no other designation, under $150,000, it's a surviving spouse, just as an example, then you may be able to manage it with simple affidavits if there's no real estate. Under $25,000, it's again, no real estate, then it can transfer to the individual subject to some limitations. So it really is going to become a question of once you determine what is part of the probate, then determine the value, and that will drive which process you have to follow in the state of Nevada.
So, what are some common types of assets that typically pass directly to someone else without going through probate?
The most common is going to be the one that I think most people think of, which is something like life insurance. Life insurance that typically is going to have a beneficiary designation. That's a non-probate asset. It's going to pass directly to whomever's identified as the beneficiary. Things like pensions or 401ks also most commonly have beneficiary designations. Part of that is the process for setting up those assets, which the institutions that are setting them up will almost put in front of the people like, hey, you need to identify a beneficiary. So those are the ones where we most commonly see beneficiary designations. The reality is, in this day and age, you can list a pay-on-death beneficiary or transfer-on-death beneficiary on almost everything you own. So Nevada DMV, for example, has its own form that someone can fill out you can transfer, you can tell the DMV who to give your car to when you die. It's a form they keep on file. And then after someone passes away, they can go to the DMV and work through that. Nevada Department of Manufactured Housing for a mobile home has the same thing. And then we have what's called a deed upon death, which functions like a beneficiary designation on a home. There are some other important distinctions, some steps required for that. Most common would be life insurance policies and retirement style plans. You really can list it on everything, almost everything these days.
So, how does joint ownership affect whether property goes through probate in Nevada?
So the legal ownership, again, that's really the first step to look at. And you need to make a distinction when you're talking about joint ownership and its ability to transfer after someone's death between real property and other assets. There's sort of magic words that are required when you're talking about real estate in the state of Nevada. For example, if the asset is owned by two people as joint tenants, and that's all it says, joint tenants. Nevada statutes state that if it's owned in joint tenancy with no other designation, that carries with it a right of survivorship. So owned by mom and dad as joint tenants, it carries that right of survivorship. There's other vesting language where you can get the right of survivorship, but it requires that you state it expressly. For example, you can take property as husband and wife, but if you want the rights of survivorship in that context, in the real property context, it has to say husband and wife with rights of survivorship, or community property with rights of survivorship. If it only says as husband and wife, it's a frustrating conversation we have with many people where they believe it should transfer because it lists them as husband and wife, but unfortunately, just that language means, with no rights of survivorship language on the deed, means that that asset will likely have to go through probate. So again, with real property, magic words like are important. It is similar with titles to like a car or a mobile home. Again, the distinction between an and an or, and how strictly they want to enforce that. But an or means what it sounds like, which either one of them is the owner of that asset. So upon death, it will be controllable by the survivor. Where oftentimes an asset like that, if it includes and, then it suggests that each of those owners has a separate and distinct interest that doesn't transfer on death. There are other ways with vehicles specifically, if that's all you're left with, that you can deal with that. So those are the big ones where we most commonly see title joint ownership is on a home or a car. Things like bank accounts, normally it's enough if both names are on it. If two names are on it, it's assumed it's a joint asset, and then it'll transfer. But it's also common for us to have to try to help people understand the difference between joint ownership, which is we both own the asset. Sometimes a child will come in and say, hey, mom, put me on the account. But what they actually mean is mom listed me as a signatory so I can help her write checks. That's not joint ownership. That's just to be able to help write checks and things. If that's the method that someone's using to transfer an asset, it's important to understand that, again, the nature of the asset makes a difference. Is it real property versus bank account? And then making sure you're clear with the institution of your intention. No, I want this person to get it when I pass, or while I'm alive, I just want them to be able to help me. So important questions you might ask as you work through that process.
So, how do beneficiary designations or transfer on death accounts change what happens to an asset after someone passes away?
I think the primary distinction is the process you have to go through to distribute that asset. It's important to note as well that if you have a proper joint ownership or proper beneficiary designations or transfer on death designations on an asset, I think again of the snapshot idea, the legal transfer is at date of death, even if functionally or practically may take a while to do it. But it also becomes institution specific. So if you're just talking about your normal checking savings account, most of the time, if you're the listed beneficiary, after the appropriate number of days pass, right, you go in with a death certificate, your ID. It may want you to fill out a form. Usually they'll liquidate the account, write you a check, and off you go. Other institutions, if it's things like stock accounts, some investment style accounts, things like that, they may require a beneficiary to create an account with that institution, and then they will transfer those assets from the decedent's account to the beneficiary's account. And then, of course, if they don't have those designations, then they're going to process through the probate process. So they're still going to have to take some steps Those are likely going to be institution specific. But if you're a beneficiary on an account, then you're going to need a death certificate, you're going to need an ID, and they're likely going to want you to sign some forms. I guess it might be a good spot too to tell people, we often tell clients, for the reasons we're talking about, if there is no beneficiary designation, it has to go through probate. Sometimes there will be an asset that they think might have a beneficiary designation, and they're worried about getting in trouble making phone calls. And I tell them all the time, there is nothing wrong. If you think you are the beneficiary on the 401k or the bank account, just call and ask and give the information you can. If you are the listed beneficiary, they'll continue to talk to you. And that's great. You can work through that process. If you're not the listed beneficiary, then typically they'll just sort of end the conversation like, hey, we just can't give you any more information. You can't draw everything from that, because that could mean one of two things. It could mean, if they stop talking to you, could mean that there is no beneficiary designation. It also could mean that simply you are not the beneficiary. Either of those could be true, but there's no harm in calling and asking that question just to figure it out.
If real estate in Nevada is held in a living trust instead of an individual name, how does that affect whether the property goes through probate?
This is another common conversation we have, and it's important that we understand, going all the way back, we talked a little bit about the title ownership idea, because oftentimes the family believes the real property is owned by the trust. They'll sit down with us and say, hey, mom owns a home, but it's in the trust. But then we look at title ownership and it's still listed in mom's name. It is listed in the trust, that's true, but it's still listed in mom's name. I guess first, to answer your question, similar to the beneficiary designations, if the asset is owned by the trust upon passing, then the trust itself is going to have some instructions about the next steps you need to take. Whomever the successor trustee, whomever is listed as the successor trustee in the trust documents, that person's going to need to come forward. There are some trust documents they're going to need to sign to confirm their role as trustee. In the context of real property, that document likely needs to be recorded. So the property records properly reflect them as the trustee, and then they can manage it as the trustee with no intervention or oversight from the court. We may have some oversight from other beneficiaries, and it's a whole different discussion, and everything that goes into trust administration, typically that's outside of court. So going back to your question, what do? They're going to have to take some steps to confirm a successor trustee and then manage the trust assets consistent with the trust documents. And then if they believe it is in the trust because it is referenced in the trust in a schedule or in the document itself, but if it's not actually currently titled in the name of the trust, then unfortunately in the state of Nevada, we are going to have to go through hopefully what is a short probate process based on recent changes in the law recent last several years that will pull that asset or pour it over based on a pour over will, pour it back into the trust to be managed pursuant to the terms of the trust.
So would that also apply to assets discovered actually later, like an old account or digital assets, if they were not included in the estate plan?
If mom or dad has a trust and down the road you discover there are assets that are not in the trust, then the process in Nevada, you're going to identify those assets. You do have to have a mechanism to get them back into the trust if that's the intention. And usually that happens in two ways. If the individual, when they created the trust, if they've done it through a law office, or I hate to say it, but a lot of the online trust creations as well, it should have with it what's called a pour over will. When we create a trust, sometimes we like to describe it as a box. Some form of a legal entity, which is a different, not a complex conversation, but it is something. You create something when you create a trust. And you should, while you're alive, you should take assets and put them inside that box. That's the goal. Or you can use beneficiary designations actually to tie assets to that box. But if you discover assets that are outside that box for any reason, then the pour over will typically says, hey, if you find assets outside of this box, give them to the box. So give it to the trust and let the trust manage those assets. In Nevada, there are also some cases that we rely on, Hegstad, Davies. Davies is in Nevada, Hegstad out of California, where they've broadened out that language to say, okay, look, if there's no pour over will, but if you can find language in the trust that clearly indicates that that asset was to be part of the trust, then you can use the language of the trust itself to pull that asset back into the trust. That's a more complex consideration. It requires a detailed analysis of the trust itself and the asset. But the goal always is to enforce the desires of the individual that's passed away. And to do that, we have to look at the documents, the trust documents and the will. But if you discover assets later that are outside the trust but intended to be in the trust, you do have to go through probate to get them back into the trust.
Well, as we wrap up today, what are some of the most effective ways Nevada residents can structure their assets so that fewer things end up going through probate?
We want to help people avoid probate, absolutely. And if they run into issues, then we can help them get through the process as efficiently as possible. I think the most efficient way to avoid probate in Nevada is a trust, just as efficiency. The reason for that, I like to tell people when they create a trust, because a trust doesn't, I know we're not getting into trusts, but your standard revocable trusts, which is what most people are creating. They don't offer creditor protection. They don't offer asset protection. It really is for the efficiency of the process after they passed. And I like to describe it as a gift to the beneficiaries. But what the individual that creates it gets is some control over how the assets are managed. So they can say, this is what I want to happen, but if so-and-so passes away before I die, then this is what I want to happen. So-and-so is entitled to it, but subject to this structure. You really get structure. You really get control over the structure in a trust that you don't get with any other estate planning methods. So efficiency-wise, it is the best you can use. There are other methods that you can use that are efficient. You just have to be a little more careful with them. We've talked a lot about beneficiary designations. It's a great way to transfer an asset. And honestly, for some assets, like your tax-deferred style 401ks, where there are tax implications, typically, for tax reasons, it is better to list an individual as the beneficiary rather than a trust. Things you should consider. But if you're using beneficiary designations as a method of transferring your assets after you pass away, you just have to be more diligent in the way that you maintain those designations. The reason for that, if you go back to the trust idea where you can control what happens if someone passes away, you have less control over that with simple beneficiary designations. You can identify a primary and a secondary, but so just one example might be if you list a life insurance policy and you say, I want all 4 of my kids, you list them as beneficiaries on a life insurance policy, and your intention is that if one of those kids pass away, that their children would receive the benefit of what they would have received. But that's not typically how beneficiary designations work. So if you have 4 kids and one of them dies before you do and you don't make any change, the outcome of that would be that it's divided by 3. And that's just how it goes. That's how it's listed. So it is a good method. You just have to be more careful. And just one plug, if that's the right word, oftentimes we'll get parents that'll ask. Usually parents say, hey, I want to put my child on my home or on my asset, list them as an owner as a method of transfer. It is not something we suggest that people do. There are other better ways. You can inadvertently expose your assets to other liabilities. There are better ways to do it. In a spousal or partnership scenario, joint ownership is a good way to manage assets. If we're talking about children or other individuals, I do not suggest you use joint ownership as a method of transfer. Deferring back to trusts is most efficient, or beneficiary designations as an option. Just being more careful with the beneficiary designations because it has other implications that you can't necessarily control the way you can with a trust.
Excellent points. Thank you. And thank you to our audience for listening to The Probate Professor. If you're navigating a probate matter in Southern Nevada, don't let the legal process overwhelm you. Visit Taylor and his team at clearcounsel.com to get the clarity you need. If you found today's episode helpful, please like, share, and subscribe to help us reach more families here in Southern Nevada. We'll see you next time. Thank you, Taylor.
Thank you for having me, Leanne. Have a good day.
You too.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.